There we go. How's it going, everyone? I'm sure some of you are wishing this would be Jake and not me, but we got the Timu Jake for today, I guess. Hopefully it works. It's definitely a lot cheaper. And anyway, lots of exciting things. I mean, I don't know if anything necessarily new, but Jake has a very calming way of outlining things. I also think he has a more organized way of doing things. Through this whole process, as soon as I find something that makes me feel like, oh, good, we won, it doesn't make me want to like keep compiling data and organizing it in a way where I can then use it for the next 2 years. You know, each time I think, hey, maybe I should start compiling things, I'm like, oh, this could be it, right? And it hasn't been it. And yeah, so it's been nice where Jake has, I mean, if you've talked to him in person, he really does just have it all in his brain. And it's all organized as far as, showing the receipts. I think showing the receipts is important. And, it says 280p me. Let's see. Let me just see if I can change that real quick. Dang. How about 480p me? Maybe that's at least a little bit better. Yeah, thanks for letting me know. Yeah, so anyway, I guess we'll just jump right into it. It's a really good read. So all right. If you want confirmation, look no further than the PRC. Okay, hello friends. I wanted to make a quick post to show that all the confirmation anyone should need that the Bed Bath & Beyond saga is ongoing can be found in the quarterly post-confirmation report. These are financial disclosures, and they are legally required to be shared 4 times a year. There are 2 critical pieces of information within them that I would consider inarguable. So let's have a recap of what they are. Firstly, we should note that the anticipated final decree, for which the majority of the entities, which we considered unwanted ones, was changed by the plan man after the deadline of December 31st had passed. This itself is incredibly reassuring because the immediate question is why? More specifically, why was the final decree for those entities not submitted? On a surface level, it does not make sense looking through the PCR submissions. These entities contain no assets or cash. There should be no reason that the plan man was unable to reach a final decree conclusion on these subsidiaries. So again, it begs the question, why didn't he? Well, it sure sounds like something isn't complete. We already know from the company's June 2023 10K that claims will continue long past emergence from Chapter 11. So that isn't the reason why. The best guess I can come up with is that the null attribute and perhaps the legacy corporate structuring is important somehow. But it doesn't matter. The point is that for the plan man to be unable to meet the deadline, something must still be ongoing within the Chapter 11. But what could it be? Let's have a recap. First of 2 concepts from the confirmed plan, the third-party release and interests. Note the capitalization. They are separate things, but relate to the same person or entity. Let's have a quick review. Released by holders of claims and interests. The release by the releasing parties, the third-party release, set forth Article XD of the plan is an essential provision of the plan. All right. So that essential provision of the plan, provision as in like had to go before, and it's legally binding. It was placed before the plan could be made, right? Very much information, very yes. This is from the plan that was submitted only after the confirmation by Judge Kaplan. A point in time which you can't go back. This snippet here is filled with information and can remember. Keep in mind that syntax and means both compared to say or and or, which would indicate either. Let's go in order. First, we can extract that the release is by holders of claims and interests, as in that holder is providing the release. This is reaffirmed for us in the words after point 38, where it adds that, in other words, whoever is the holder of claims and interests is also the releasing parties. And immediately after, we get confirmation in parentheses that this arrangement is the third-party release. Let's assemble it all. This specific language by holders of claims and interests is the third-party release. Lastly, the releasing party is a non-debtor. I can't stress that enough. Painful, but important. And quickly, we will see why from the confirmation plan. Interest means any equity security as defined in section 101(16) of the bankruptcy in any debtor. Snap into a Slim Jim. Remember, capitalized words matter. When the word interest is written with a capital letter, it only means what the definition page states the word means. Moreover, at the time of the submission of the document, September 14th, 2023, there is only one kind of equity, the company. There is only one kind of equity in the company, the Class 9 common stock. Sidebar, which is when the judge was talking with the lawyers. Don't miss that on September 14th. The attorneys at Kirkland made the clear inclusion that this interest can be expanded to any debtor subsidiary of the company. More on that later. Therefore, we can apply some reasoning here and expand this precision crafted legal language. In the case of the holders of claims and interests, remember interests, which means that there is a holder of Class 9 common stock on September 14th, and this holder of Class 9 common stock is also a participating releasing party within the third-party release. Why is that important? Well, the third-party release is involved in something very significant that we also learn about within this plan that is only shared after the confirmation. Entry of the confirmation of order shall constitute the bankruptcy's court's approval pursuant to Bankruptcy Rule 9019 of the third-party release, which includes by reference each of the related provisions and definitions contained in the plan, and further shall constitute the bankruptcy's court's finding that the third-party release is consensual, essential to the confirmation of the plan, given in the exchange for goods, the good and valuable consideration provided by the releasing parties, including, without limitation, the released parties' contributions to facilitating the asset sale transaction, and implementing the plan, a good faith settlement, and a compromise of the claims released by the third-party release. I should just add in, it's interesting that the board's being sued for the share buybacks and their secret meeting with JP Morgan and Goldman Sachs, but yet we haven't seen them do a lawsuit against JP Morgan or Goldman Sachs, which means maybe, just maybe, that's who is connected to this third-party release. In the best interest of the debtors and their respective estates, fair, equitable, and reasonable, which, just in case I forget, fair, equitable, and reasonable, they couldn't be adding creditors or claims after the bar date. There's lots of things that of flexibility that wouldn't happen if this was all fair and equitable, and there wasn't some big pot of money that was guaranteeing the whole process and guaranteeing that everyone is made whole. Given and made after due notice and opportunity for hearing, and a bar to any of the releasing parties asserting any claim or cause of action released pursuant to the third party release. Oh yeah. The third party release was a critical component of the asset sale transaction. So let's expand our language again to include the critical component that whoever is a holder of interests was also the purchaser in the asset sale transaction. Let's bring it back. At the beginning of the post, we highlighted that the PCR is the inarguable confirmation that Bed Bath story is not done. How can I state this? Well, let's look at the PCR. Part 3, recoveries to holders of claims and interests under the confirmed plan. Total anticipated payout under the plan is unknown at this time, right? And this was just several days ago, right? This was January 21st, okay? This is why the plan states that multiple of the debtors' businesses will emerge as a going concern. The plan confirmed it. The 10K confirmed it. The null preservation requires it. So logically, the only question outstanding should not be if something is going to happen with Bed Bath. The question should be, who could the holders of interest be? This is solely my opinion and not based on any material non-public information. Why the co-debtor, of course. Why the co-debtor, of course. It just makes sense. Once we understand, have a scroll up and reread the definition of interest. Remember how we pointed out that it can mean any equity security in any debtor? Isn't that a strange thing to include in the definition? Not at all. Once we understand the mechanics of the divisive reorganization, something referred to as a butterfly transaction. Fun fact, the term butterfly transaction is almost exclusively only used in Canada. Wow. In the US, the structuring is most often referred to as a divisive reorganization, or IRC, Internal Revenue Code, and then the number that corresponds to the law that oversees the specific transactional framework. In case you are not a visual learner, what the above graphic is explaining is the divisive reorganization. It boils down to 4 parts. Allow me to explain them with the Bed Bath & Beyond specifics added in so that they make more sense. The acquirer, in the Bed Bath case, is the holder of interests, who is the party to the asset sale transaction, wants to buy one or some subsidiaries of the parent company. The way this happens is that the acquirer will pay for the asset subsidiaries with cash, and in exchange, the parent company will give the acquirer all of the security interests, stock that makes up the ownership of the subsidiaries. Then the acquirer will surrender, give up, extinguish, exchange all of those shares, and in doing so will receive the ownership of the subsidiaries for themselves. You can't have so if the shares are written, they can't be written. You can't have shares that say Bed Bath and subsidiaries, and then also have shares for the subsidiaries. So the original shares do have to be canceled if new shares are rewritten, right? Which, remember, Bed Bath and Bye Bye Baby entered bankruptcy as separate companies. Just a little further clarity on that. Lastly, 3 become 2, and you have the parent company, the estate, with cash, and the acquirer with the subsidiaries. It should now make sense. Well, that would be the cash would only come in after the waterfall, right? So since we haven't seen the waterfall, we haven't seen that money come into the parent company, right? So the plan admin is in charge of the parent company, and that money hasn't come in yet because the waterfall hasn't come in yet, because there's still things that have to be dealt with, that we don't know which one of those things is important, right? But that waterfall will come. And anyway, I'll continue with Jake's post. It should now make sense why the plan describes the word interest as referring to equity in any of the debtors. This is the asset sale transaction described within the third-party release. As an additional benefit, this is structured in the specific manner so that it is considered a tax-free event. Fun fact, this exact thing is described in the confirmed plan. Gotta love Jake and his receipts. All right. Section 1146 exemption. To the maximum extent provided by 1146A of the Bankruptcy Code, any transfers of properties pursuant hereto, including the asset sale transaction or the issuance, transfer, or exchange of any security under the plan, shall not be subject to any document recording tax, stamp tax, conveyance fee, intangibles, or similar tax, mortgage tax, stamp tax, real estate transfer tax, mortgage recording tax, or other similar tax or governmental assessment. And upon entry of the confirmation order, the appropriate state or local government officials or agents shall forego the collection of such tax or government assessment, and except for filing and recordation any of the foregoing instruments or other documents pursuant to such transfers of property without the payment of such tax, recordation fee, or governmental assessment, right? So we do see that something that's holding it up, or maybe it's not holding it up. Maybe it says that that pursuant to this transaction or the transfer exchange, right, that was set into motion under the plan, that's when it says right here, and upon entry of the confirmation order, the appropriate state or local government officials or agents shall forego the collection, right? So either the IRS is resisting that, right? There's two different ones. There's, I don't know if it was Texas and California, right? And the comptroller in Texas, right? It was a comptroller in New York that was trying to stop, to propose those weird DEI stuff for GameStop, right? As a way to get rid of board members or get rid of RC. So definitely the IRS has been weaponized, but right here, it straight up says in the confirmed plan, which the judge did confirm, it says that upon entry of the confirmation order, right? So either that confirmation order hasn't been fully implemented because of the tax claims, or the tax claims just have to be thrown out because it conflicts with this. Either way, that's really great to read right there. It's as if it were intentional, ? Read it again. The issuance, transfer, or exchange of any security under the plan. This should be to no one's surprise, but regardless, it is enjoyable to see the further confirmation documented within the plan. In summary, the PCR filed by the plan man shows that the estate is still reserving the rights of the holders of interest even in January 2025. That means nothing has changed. The holder of interest is a Class 9 shareholder, because that is how the plan defines interests. And Class 9 common stock was the only equity that existed at the time that the document was submitted. Want to see it? Want to see another confirmation? Sure. Cancellation of securities. Cancellation of securities and agreements on the latter of the effective date and the date on which distributions are made pursuant to the plan, if not made on the effective date, except for the purpose of evidencing a right to allowing holders of claims and interests to receive a distribution under the plan, allowing the 2014 senior unsecured notes trustee to exercise its charging lien in accordance. So see how, so, okay, this is, except for the, so it says, if not made on the effective date, right? So that means that there was a chance that these distributions could have happened on the effective date. But what else happened at the same time? Well, the 2014 senior unsecured note trustees could exercise their charging lien, right? So we did have the first Pulte event right around this time. And something that was interesting was 14% of these bondholders, I can't remember off the top of my head what his name was. So they voted to block the plan, right? To reject the plan. And I remember specifically in court that the debtor in possession of Bye Bye Baby, which is 6th Street, their lawyer said they were asking these note holders to not exercise their charging lien. And the note holders were insistent, and they said, the judge said, if you knew who the guarantor was, you might be more willing to do it, right? And if you want to have an NDA, then you can find out who that is. And the Kirkland Ellis lawyer said, right now there's nothing to sell because they'd be in this stalemate, right? But if you let go of your lien, then there might be more than enough to go around, is what he said. I remember watching that in the court, right? So it's awesome to see it right here, and that we really could have received this distribution all the way back then. I think this was like October, I think was the court date that I remember. But it also might have just happened on September 29th. Anyway, we're here now, and all those things are being dealt with, but there's a lot of things that don't have precedent, and it takes a while to, I guess, unwind all this. Jake says, don't tease me with a good time. Specifically, as it relates to the cancellation of common stock, the confirmed plan is outright stating, on the latter of the effective date and the date on which distributions are made, if not made on the effective date, as in just because it hadn't happened by September 29th does not mean it cannot happen. There is an exemption to the cancellation of the common stock, allowing holders of claims and interests, remember interests, to receive a distribution under the plan. Ask yourself, why would this statement exist in the plan if it were not necessary? If it were not necessary, it wouldn't. These are not amateur attorneys. It exists because it is necessary. This is how. This is also why the U.S. trustee had to object to the confirmation of the plan. In hindsight, had we all been experts in reading legalese, this objection was the ultimate confirmation. Want to see? Sure. This is the U.S. trustee. The U.S. trustee argues that the third-party release is overboard and impermissible in that it contains, as a releasing party, all holders of claims or interest who actually just says interest right there. That's fascinating. Who vote to reject the plan and who do not affirmatively opt out of the releasing provided by the plan. The U.S. trustee further argues that the gatekeeping provision should be removed from the plan. The U.S. trustee requires other revisions to the releases, injunction, and exculpation provisions through an informal objection. Okay. The debtors have agreed to make various changes to the plan to resolve the U.S. trustee's informal objection, including the removal of holders of claim that are deemed to reject the plan from the definition of releasing parties, and agreed upon revisions to the injunction and the exculpation provisions, each of which will be reflected in a further amended plan filed in advance of the combined hearing. Oh, that's cool. So this was, okay, never mind. So they did, because this was on September 7th. As of the filing of this confirmation brief, the only outstanding issue with the U.S. trustee related to the third-party release as it relates to parties who vote to reject the plan, addressed in the confirmation brief at Art 4B. Anyway, the gatekeeping provision. The debtors remain engaged in ongoing discussion with the U.S. trustee around further revisions to the plan and hope to reach a resolution in advance of the combined hearing. Don't tease me with a good time. Is overboard and impermissible in that it contains, as a releasing party, all holders of claims or interests, as in all of Class 9, who vote to reject the plan. Another layer of confirmation that it is Class 9, since that class was being labeled as deemed to reject. That'd be interesting, because if Ryan Cohen was making the plan go through, but then he was deemed to reject, right, the plan, like automatically without voting, then, that would mess up the plan, right? So especially if he, through the HBC deal, has more than 50% of the shares, then obviously they can't just automatically make everyone deemed to reject. Then have a look at the rectangular highlight as well, confirming even further, not like it is required for the conclusion, that the reference is to Class 9, as the language does not contain interests, which isolates the possibilities to only Class 9, holder of claims and deemed to reject the plan, and also confirms that this is the releasing party, going back to the third-party release. Why is this taking so long? I have no idea. What I do know is that there is an abundance of information within the confirmed plan that states that something is at the end of the road, and just because it is taking longer than anyone anticipated does not mean the outcome is any less likely. Hang in there. Also, I added this picture. So, let's see. There's a few comments I wanted to make. I didn't want to interrupt the flow too much. One is, okay. So, something that was interesting, trying to think of in which order to do this. So, Bed Bath & Beyond went into bankruptcy before, in Canada, before it went there in the United States, because J.P. Morgan, in order to block the bond exchange deal, they imposed cash dominion, right? And part of that is there's, in the Canadian bankruptcy code, in their Bank Act, right, section 427 actually says that when they basically, like, that the money put into the bankruptcy, like as a loan, turns into shares, right? So they would have these shares of basically this sort of dip loan, I guess you could say, this debtor in possession loan, would have shares connected to it, I think kind of automatically, due to this section 427 of the bankruptcy code. And we see this this is the factum from, it's actually from Alvarez and Marsal. So in the and the matter of a plan, compromise, or arrangement of the BBB Canada. Interesting that specifically that one. So one thing that I found was interesting was that the cash dominion portion was struck out, right? And so let's see. So basically, if let's see, did it say? Cash dominion period. Okay, right here. Means the period commencing on the second amendment effective date until all obligations have been paid in full and all commitments have been terminated, right? So what are some of these like commitments, right? Well, I mean, you have all the claims up to that point, and we do, I think it was Dirtivator maybe, or someone else, I can't remember, but they found where all these revolving claims that had been building up that JP Morgan actually owned, that Sixth Street had actually bought them from JP Morgan. So maybe that happened in this period where all those claims, so, you know, if JP Morgan says, well, you can't have Bye Bye Baby, or you can't have this or that because this claim, this claim, this claim. Well, so that's interesting, right? So someone bought it, right? Through this, supposedly it was like, it wasn't HBC. It was through this, supposedly it was B. Riley, which I don't know. Anyway, the Canadian one, there's a lot there. I need to go back through it and straighten out. But to find out whether it really was B. Riley or if they were just partially involved with it. But it's interesting that if these claims had been terminated and that somehow Sixth Street ended up with these revolving claims, I think it kind of shows who the main player was this whole time. And this was back all in February 10th, 2023. So they bought the claims, the commitments, and the obligations, right? I think this is maybe where they had either made a plan to pay off the ABL loan or whatever it is, but this couldn't have been struck out unless it was actually paid. And if it was paid, then what was gotten in return, right? Because it's possible that they can basically, so let's say that Sixth Street is, so there's two people that have senior secured, like they have top priority lien on Bye Bye Baby, right? And one is Sixth Street, one is JP Morgan. Well, if JP Morgan gets paid off, then basically Sixth Street would have first pick for whatever they wanted of the company, right? And so if they said, okay, well, we want Bye Bye Baby, right? Then that's when this leverage buyout could have happened, right? And they said, okay, we want Bye Bye Baby, and we're going to guarantee all of the debt of the whole company, right, in order to take this, right? And so all that money would be in a trust, and it's there, and the judge knows it's there, right? That's why, you know, things can go forward. And all that doesn't completely wipe out the liens less than it, right? The money has to actually go through and actually pay the people, but it gets JP Morgan out of the way, and it puts Sixth Street in first priority position. And so then the deal can all be set up for Bye Bye Baby, and those shares that were created for Bye Bye Baby in Canada when they gave that money, those shares would still be connected to Bye Bye Baby, right? the old shares that have written in there that it's for Bed Bath and Beyond and for Bye Bye Baby, those ones would have to be canceled, right? And to sort that out, they would have to go under the jurisdiction of the bankruptcy court, because it would be a total mess. Because, we heard Sue Gov talk about her plan. She's like, oh, we're going to do this and all women's board that and all these things, right? And all we have to do is, vote for the reverse split, right? And then in the deposition, come to find out, they said she had no idea what she was talking about. None of that was true. And so it's because basically they had the company through Canada, but it was kind of, one, I guess they knew it would have to be sorted out, but I guess people didn't really know who owned what. Everything was so hidden, right? It's not just bad guys that muddy the water so that no one knows what they're doing, right? And so if this is all hidden in Canada, they would be, whatever bank is underwriting this would be the only ones who would know what was going on. And so then you would just have to so then you had you have the third party release money, you have the guarantor money, right? It's no wonder that after, so this bankruptcy happened February 10th, right, in Canada. And then, so the cash dominion is lifted, right? The debtor is reorganized in Canada, right? So, one of the shills actually posted this, right? Trying to debunk what I'd said. And this is a post I'd made like a long time ago, right? Bed Bath & Beyond website to return in Canada after bankruptcy, right? Because, anyway, the American online furniture retailer Overstock has purchased the digital right to Bed Bath & Beyond with the goal of bringing the beleaguered store's website back up and running in Canada, right? So that doesn't at all debunk what I'm saying. What I'm saying is actually that Bye Bye Baby had shares created, and that's why, Sixth Street is the debtor in possession of Bye Bye Baby, right? Like the plan admin, a lot of people get this confused. He has no jurisdiction over Bye Bye Baby. He only has it over Bed Bath & Beyond, right? The only thing he deals with Bye Bye Baby is handling claims that come in, right? They handled ones that came in during bankruptcy, but he's supposed to handle ones that come in after bankruptcy. And he deals with the distribution, right? Well, because the distribution, like Jake had said, the money from the subsidiary, from Bye Bye Baby, has to come in and go in and pay all the debts of the parent company, right? And in that process, there shouldn't be taxes, but for some reason there is, right? And that will be sorted out, hopefully sooner rather than later. But yes, so the Bed Bath & Beyond, starting back up in Canada with, Overstock in charge of it, like that's totally fine. Has nothing to do with what I believe our BBBY shares will come back as, right? Because the Bed Bath BBBY, the ticker was preserved for the estate before Kirkland Ellis even left, right? Sorry to jump around a little bit, but in I guess common fashion. Let's see. Let me just switch to this page. Okay. So, yeah, I should, anyway, here's a few questions, right? A few more questions that kind of come to mind in this whole process. So why would they allow for claims after the bar date if there wasn't any money, right? How could they they would just turn them away, right? The plan admin has the ability to say that, right? He could just be like, there isn't any money, and sorry, go away, right? But that's not the case. They kept accepting way past the bar date all these claims, and the judge kept saying, oh yeah, we'll be flexible, don't worry, blah, blah, blah. Okay, so that wouldn't happen, right? Why wouldn't other creditors who have been promised 0 to 2.5% not object to more claims being added, right? They have a valid, they could easily just submit something saying like, hey, like you're not allowed to have people past the bar date submit their claims, right? But they didn't do it. Remember how the 14% of the bondholders rejected the plan until they got an NDA to see who the guarantor was? Remember how 6th Street, the debtor in possession of BBBY Baby, had told the bondholders that there wasn't anything to sell, but if they gave up their lien, that there likely to be more than enough to go around. Remember how it wasn't until after that BBBY Baby website went up. Also, shout out to PP. It was like the day before the BBBY Baby website went up. We had someone in the backstage chat, say that it was going to happen, right? So, kind of a confirmation that, because the physical stores itself, kept going, right? And that's what the shared IP was with the BBBY Baby as a going concern, which was different than the website. Those were owned by two separate people, and we saw that more so. Control Chaos and Jake2B actually went and saw they are separate. They have different HR departments, everything, right? And one is winding down. It had to stay up just until the net operating losses 2-year change of control time period was up, or might still have to be up, right? It might be till March 3rd or March 30th because of the shares. There isn't clear precedence. I don't know. I guess we'll just find out. It could have been as long as back in August, right, of last year. Remember how Bed Bath and Beyond and BBBY Baby entered Chapter 11 as separate companies? Remember how Michael Goldberg has nothing to do with BBBY Baby, which was reorganized, not liquidated, except handle claims that come in for it and handle the distribution when that time comes. He would have no way of knowing how much money was in BBBY Baby because 6th Street is the debtor in possession of BBBY Baby. And they're also, BBBY Baby owns whatever subsidiaries it might have taken under its wing. All that they would have had to do was guarantee the debt attached to the subsidiary, and it would be theirs. Remember how 6th Street finished up their September, how 6th Street finished up their side of the deal September 14th, 2023, and the plan was confirmed September 29th. Remember how 6th Street didn't come back until MJL's shareholder case? Why couldn't Goldberg just handle it? In that case, what was the judge talking about when he referenced other pots of money that are full but cannot be accessed until the triggering event? Why would they even allow MJL to appear in court if his interests in BBBY were canceled half a year prior? There are a lot of questions that all point to one thing, which is the reason why Ryan Cohen has never come out and said he is not involved. Because he is involved. He easily could just say no. I know he will see this. I'm sure he is busy working hard, but he will see this. And I'm not at all scared. Possibly we have to wait until the new IRS court date, which is April 8th. The potential change of control date, which is March 30th. The anniversary of the ice cream tweet, which is February 24th. Or when the new FBI director is confirmed on January 30th. It is not a matter of if, but a matter of when, right? Anyway, there's a lot to be excited about. I'm gonna see if um, I think that might actually be good, good for right now. um, let's see. I am still very excited, and I think actually one more thing that's just kind of an interesting side note, I guess, while people are here, is does anyone did anyone know, right? This is Joe Fonicello, right? He's the head of social media for GameStop, right? Um, that's kind of interesting, right? Because he, let's see, so many posts. um, right? He had this, September 29th, cancel, released, and extinguished, right? Kind of interesting. Um, he had Rod Alsman, right? Um, and so it's kind of fascinating then to see him after this get hired by GameStop. But what's also interesting is he then doesn't really tweet. Definitely doesn't tweet about Bed Bath or anything, And he did, yes, he did do the interview with RC, Andrew. So also it's just kind of interesting. Bill Ackman, right? He was kind of on the other side of Carl Icahn, and so I just think that there, I don't know, could just be. I think unlikely teammates came together, right? Bill Ackman and Carl Icahn, at some point behind Trump, ended up converging. I mean, maybe it really was. Maybe who knows how long Ryan Cohen has been on board. I mean, if this was supposed to have happened under Joe Biden, I mean, who knows what the plan could have been. I mean, I think that his laissez-faire kind of stuff and everything else is kind of leading to that, Ryan Cohen, the plan has been with Trump for a long time. Or maybe, I don't know, actually I could see it going a lot of ways. Maybe now that I think about it, because there's JD Vance and Elon was, going to be supporting JD Vance. So anyway, it all could have definitely turned out different, I think. But I do think that things changed, and also, just listening to this, I'm not recommending to listen to this, but they're Rod Alsman even admits, he's like, yeah, the board totally screwed up and did all these really bad share buybacks, right? But he said there's no lawsuit against it. Well, now we know there is a lawsuit against it, and that's not some chump change amount. It's 2.5 billion, and so the current debt is 1.4 billion, right? That's about a billion of bond debt, and 400 million or so of Sixth Street loans, right? Which Sixth Street said they were going to do a credit bid. They still haven't done a credit bid, right? And if you look at their filing, it we went over in the PB show like several weeks ago when they filed, and it definitely looks like they're planning on doing a credit bid still, right? I'd have to have the details in front of me to go further into that, but we are good. We're definitely good. I do think that I think that there's other mergers that are going to come along with this. I mean, Carl Icahn said there's lots of mergers that have been waiting, and we've seen all the federal agencies been weaponized against it. I mean, the FCC was one who shot down the Kroger and Albertsons deal, right? So, and the Spirit and the JetBlue. I mean, if there's like one big unit investment trust, and it was all planned to be this huge omni-channel, which is something that doesn't exist yet, right? Where you have like in-store, online, but in like to a greater depth, you would want something like Kroger. And so if there's this huge fund that's going to buy, all these companies, this huge trust, I mean, we kind of now see who those players likely are, right? We see that, keep reposting this picture because it's, hold up. I really got to post a little less, man. You can see who the people in this big merger likely are. There we go. Right. So you have, Elon Musk, you have Trump, you have Pulte, you got Ryan Cohen, you have this Sultan Al-Madid, right? And so I just think, Javier Milei, and, you got the prime minister of or president of Italy, right? And I'm sure you're going to have, and then you have the president of El Salvador, and I think it's just going to spread. This, when you get someone like the Sultan Al-Madid, I mean, he could have money, if he dumped in, tens or $100 billion, right, into this trust. Maybe Saudi Arabia did as well. Maybe the UAE did as well. I mean, we do have someone from, we have some people from Dubai that are part of this, part of the Bed Bath community, right? So all that money could be in a trust. It just has certain a mechanism of how it would, that money could be used, right? And the triggering event, hasn't happened yet. So I think this is huge. I also think, now that I'm thinking about it, that there is some things we're waiting for, right? But they do seem like they're right around the corner. For example, this, right? Fifth. I mean, just also that is cool, right? X is the 5th most visited website in the world last month. Can you imagine once they have their e-commerce or omni-channel store, like how much money is going to go through there, like instantly, right? It's going to be a lot, right? So, I mean, we are set up to be part of one of the biggest game changers that's happened in a very long time. I mean, possibly since World War II, right? This is actually the post that I was looking for, right? So X payments is coming soon. I do think it's critical to this. We saw that T0 just got permissions for a lot of things, one of which is to be a transfer agent. So, our shares could go from M3 Partners or whoever or Wilmington Trust. I can't remember who it is that is the likely transfer agent for our Bed Bath shares, but they could just be moved over to T0, right? And just like Jake had mentioned, it's almost worth rereading that portion, but basically it said that the shares would be canceled, but it was so good when I read it. I just wish it's slightly, oh yeah, here we go. Cancellation of securities and agreements on the latter, the effective date and the date on which distributions are made pursuant to plan, right? Distributions have not been made yet. Okay. If not made on the effective date, except for the purposes of evidencing a right to and allowing claims and holders of interest, right? So basically, shares will be canceled, right? Except for showing who has a right, right? So it's like, so the share gets canceled, but basically the evidence of who has that interest in BBBY is still there, right? This is like, I read this and I was just like, wow, thank you, Jake. I mean, I love the whole thing by Jake, but like him putting this out there just really got me excited, because that is what's still there, right? Our interest, the evidence of our interest, so that we can receive a distribution under the plan, right, is there, right? And now that T0 can be a transfer agent, right? That could be moved over, right? And also, just for clarity, right? There's my post earlier. I guess some people, for some reason, had their feathers ruffled. I meant like now got autocorrected to not. So I said, anyway, now that that T0 is a transfer agent, right? Because that is one exciting thing that we have been waiting for. So I think we're all lined up. I think, it could just be the money license, the money transfer licenses for X payments that we're waiting for, which, they haven't really updated how many they have. The last time they updated it was like a couple months ago, and they had 38. And here, just out of nowhere, it's kind of funny. I posted about it yesterday, and then today they came up with one. So I don't know. That's kind of cool. But yeah. So I mean, this could mean that, and actually the states that were still on the list, I mean, all like a lot of them were actually red states, which I would just assume that they would hurry up and do that. Also, New York seems to be kind of switching sides, so I think that they would as well. So I think we're good on that. And they already have California, actually, surprisingly, I think. So that, in my opinion, would have been the hardest one. And I think XRP had well, it says it ambiguously stated what it had. It says it has 50. Over 50. So I don't know if that means all 50 states or what it means. T0 has been licensed, I think, in all the states or close to all the states. So I think we're set. And yeah, I think we have a lot to look forward to, and I'm very excited. I hope it doesn't take all the way till April 8th, because that would be really annoying. But if it does, I mean, the third party release, was a meaningful amount, and it made the whole plan possible. And so the whole plan would have been possible because, I mean, there was, for all they knew, there was at least 5. I mean, that's actually how much there, it's said that the debt was when they entered bankruptcy. In their last statement, I think it said it was like $5.5 billion, right? So that means that if the third party release, the third party release alone made the whole plan possible, that means there'd have to be at least be $5.5 billion as that settlement, right? And since it's with JP Morgan, and since the whole company was lost, you think about like the market cap, what the market cap of Bed Bath & Beyond was when they went into bankruptcy, and that they completely lost. So, I mean, when they started doing the share buybacks and all the shenanigans, which I'm not sure what their market cap was, it was definitely over 5 billion. So I think there's at least 10 billion in that trust, which at a max TSO, if they were doing as much debt to equity conversion and all that, that still comes out to be like $15 a share. So just the lawsuit against the board of directors, that 2.5 billion with the max TSO, that would still be like $2 to $3 worth of cash distribution, right? So that means we get our shares back plus $2 to $3, even if the third party release, wasn't there. So I think it could be a large amount, right? It could be $100, right? I don't know. But I'm very excited, and I think it'll be very worth the wait, and hope you guys have a good rest.